hospital hallway in Los Angeles, late at night. A man sits down at the end of a long shift. A sheriff's deputy takes out a pen. No recorder on the table. No warning spoken first. Just a page and a signature waiting at the bottom of it. He signs. And the warning you can recite from memory, the one you have heard in 1,000 arrests on 1,000 screens, never came. If they never read you your rights and your own words go on trial in your place, can you ever make them answer for that? You think you know these words. You have heard them your whole life. The right to remain silent. The warning that anything you say can be used against you. Most people believe they know exactly what that promise protects. Almost no one has ever been shown where the protection stops. Because there is a difference, rarely spoken out loud, between holding a right in your hands and collecting anything at all when someone breaks it. You can own the words. You can also watch a man who owned them just as fully and learn they came attached to nothing. It runs from a signature on a hospital table all the way to the highest court in the country, and it ends on a line almost no one has ever had drawn for them. This is prime documentary. In 2014, inside a medical center in Los Angeles, a man named Terence Tekoh went to work. He was a hospital employee. To the people moving past him, an ordinary face in a corridor, the kind you forget the moment you have passed it. One afternoon, a Los Angeles County Sheriff's deputy named Carlos Vega came to question him about a complaint someone had made. What that complaint said does not belong at the center of this film. A jury would later hear all of it, weigh every piece, and refuse to convict. So two facts sit side by side and they stay that way. He was suspected of something serious. He was later cleared of it. A private person, accused and then let go, and he is spoken about that way here. What matters is the room and the paper that came out of it. Vega asked his questions. The conversation went on for a while. And by the end, there was a written statement in Tekoh's own hand, lying on the table between them. Something was missing from that room. Before a single question was asked, no one told Terence Tekoh that he could stay silent. No one told him the page he was filling out could one day be carried into a courtroom and read aloud to the people deciding whether he walked free. The warning never came. That statement did not stay behind in the hospital. It traveled. It went to court. Terence Tekoh was charged and he was put on trial, and the words he had written with no warning became part of the government's case. His own hand turned into the evidence against him in front of 12 strangers. Then those 12 strangers did something. They acquitted him. The ordinary man from the corridor walked out of that courtroom not guilty. And yet he had already sat across a table from his own written words in open court. He had already watched a page, taken without the famous warning, become a weapon in the state's hands. So he did what the law openly allows a citizen to do when a government official steps over a constitutional line. He sued the deputy. One distinction now decides the whole case. He was not trying to send Carlos Vega to prison. This was no criminal charge against the officer. It was a civil claim, and what Tekoh wanted was money. Damages. Accountability measured in dollars for a wrong he believed had been done to him. He brought that claim under a federal law with deep roots, known today by nothing more than its number in the code. Section 1983 was written in the raw years after the Civil War to give ordinary people a way into federal court when the state itself becomes the wrongdoer. It lets a person sue a state official who strips away a right the Constitution guarantees, the everyday tool for holding police and other officials personally answerable in a civil court. It is a door to hold him to account. Tekoh's road down that path was rough. Twice, federal juries heard his civil case, and twice they sided with the deputy. The first verdict was thrown out over a flaw in how the jury had been instructed, so the entire case was tried a second time, and a second jury again returned a verdict for Vega. Tekoh appealed that second loss, and his appeal rested on one precise complaint. He said the trial judge had refused to tell the jury one crucial thing, that using his unwarned statement at his criminal trial was, by itself, a violation he had every right to sue over. A federal court of appeals looked at that argument and agreed with him. It ruled that using such a statement against a defendant at trial could violate the Fifth Amendment and could support a lawsuit under Section 1983. It sent the case back for yet another trial. And that is the moment Carlos Vega asked the Supreme Court of the United States to step in and settle the matter. Everything now narrows to one small, almost technical question, and the entire weight of your rights comes down on the answer. Nobody in that courtroom was fighting about the famous case. In 1966, in Miranda versus Arizona, the Supreme Court held that before police question someone who is in custody, they have to deliver the warnings you already know. The right to say nothing, the fact that your words can become evidence, the right to a lawyer appointed for you if you cannot pay. No one was fighting about a second, quieter decision either. In the year 2000, in a ruling called Dickerson, the court confirmed that Miranda was not a suggestion or a courtesy. It was a constitutional rule, rooted so deeply that Congress could not pass a law to sweep it away. So when the case reached the Supreme Court, Tekoh's argument sounded almost like arithmetic. If Miranda is a constitutional rule and an officer broke it, then the officer stripped him of a constitutional right. And Section 1983 exists precisely so a person can sue for the loss of a constitutional right. Rule, broken, remedy. Simple? The majority did not see it as simple at all. Writing for 6 of the 9 justices, Justice Samuel Alito drew a distinction that is careful, technical, and enormous for you. Miranda's warnings, he wrote, are what lawyers call prophylactic rules. Picture a protective fence built around a deeper right. The Fifth Amendment promised that no one can force you to incriminate yourself. The warnings guard that inner right. But the warnings themselves, the majority reason, are not the constitutional right. A fence, not the ground it stands on. From that one distinction, the rest follows. If the warnings are only a safeguard and not the right itself, then failing to give them is not, on its own, a violation of the Constitution. And an injury that is not a constitutional violation is not the kind of harm Section 1983 was ever built to repair. So, the deputy could not be made to pay money damages simply because the warning had been left out. The majority insisted the warning still carries real weight. Skip it, and a criminal court can still refuse to let the prosecution build its case on your unwarned words. That protection at trial, Justice Alito wrote, is remedy enough. What the court closed was only the second door, the one that opens after the trial is over. The lawsuit that turns a missing warning into a bill the officer has to pay. That is where the ruling leaves you. Imagine your own chair in that hospital room. You are questioned with no warning. You are tried on the words you wrote. And even if a jury clears you, the way one cleared Terence Tekoh, this decision means you cannot later walk into a civil court and ask the officer to pay for the warning he skipped. The safeguard you always assumed had a price tag behind it does not. 3 justices refused to accept that. In dissent, Justice Elena Kagan, joined by Justices Breyer and Sotomayor, went straight back to that overlooked ruling from the year 2000. If Miranda truly is a constitutional rule, she argued, then it hands you a real and enforceable right, the power to keep an unwarned confession out of your own trial. A right that no remedy can back up, she warned, slowly stops feeling like a right at all. The Constitution, in her reading, does not hand you a promise on paper and then leave you with no way to enforce the most personal one you own. Take away the ability to sue, and some people whose rights are genuinely broken will be left standing there with nothing to collect and no one to answer for it. The headlines will flatten what comes next into something it is not. What actually changed is smaller and far more exact. The court did not erase Miranda. It said so, plainly on the page. Miranda stands. Dickerson stands. If police question you today without the warning, your unwarned words can be thrown out of your criminal trial. That protection, the power to keep your own statement away from the jury that decides your fate, is fully alive, and nothing in this ruling touched it. What the court closed was a single door, and only that one. The door marked "Sue the officer for money" in civil court, purely because he failed to warn you. On that theory, standing by itself, the door is now shut. So the exact words matter here. This is not the death of the right to remain silent, and it is not permission for police to stop reading anyone their rights. It is a line drawn between 2 things most of us have always treated as one. On one side, the rule that shields you inside the trial, keeping your unwarned words away from the jury. On the other, the check you might have hoped to win from the officer afterward. The first survived this case whole. The second, for a warning skipped and nothing more, did not. Under all of this doctrine, there is one life. Terence Tekoh was accused of a crime. A jury heard the case in full and let him go. His own written words, taken with no warning, had already been carried into a courtroom and used to argue he belonged in a cell. When it was over, he turned to the civil courts to hold the officer accountable for that. And after the highest court in the country had finished speaking, that particular road, the one paved with Section 1983, was closed to him. So the question we opened with finally gets its answer, cleanly, with nothing stretched. If an officer never reads you your rights, can you make him pay for that single failure on its own in a lawsuit for damages? After the summer of 2022, the answer to that narrow question is no. But your silence has not lost its power in the one place it was always built to matter most. In the room where you are, the one on trial, an unwarned statement can still be kept out. The warning still shapes what a jury is ever allowed to hear about you. The gap this case opened is real, and it opens long before you ever sit in that chair. A right and a remedy are not the same thing. The shield is the part the law still raises for you. The payment was the part you had to win yourself, and for a warning skipped and nothing else, that is what this case took away. You can hold the first of them firmly, reach for the second in the same breath, and find that the civil damages remedy for that failure alone was never there to take. If this is the kind of line you want drawn in plain words before the day you actually need it, stay with us. At Prime Documentary, we keep reading the fine print of your rights out loud, one case at a time.